All right. Welcome, everyone. Manong Desai with Malabar Hill Capital. This is our third in our webinar series. We do various webinars. A lot of times they're associated with our offerings that we have at Malabar Hill. But most recently, we started webinars to focus on certain aspects of commercial real estate. We've gone through asset classes. And most recently, we talked about syndications. And a good friend, colleague, Brad Porter, agreed to join us and talk about title issues. With Malabar Hill, my fearless partner, as well as Brad's legal teams, address a fair amount of the title issues. But I will say that it is one of the things we talk about every day. If you're in real estate, as a lot of you all are, we talk about it on a daily basis. So just to kind of start off by introducing Brad, I've got to know Brad very well over the last 3 years. Really at the start of the inception of Malabar Hill Capital, we were introduced. He is a real estate attorney. In fact, board certified with the Texas Board of Legal Specializations in Commercial Real Estate. An interesting fact is while Texas is about 10% of the landmass of the U.S., there's less than 400 attorneys in Texas that have that board certification. So I feel humbled to call him our attorney. As it really relates to his approach to real estate law, I would say it's pragmatic. There's a lot of ways to look at transactions. You can be a facilitator of deals, or you can put your litigator hat on and kill deals. And what we have found is he facilitates deals. And I think a large part of that is because he is an active investor himself. Coming in to transactions with that type of skill set is definitely helpful. Kind of turned over to you, Brad. Again, appreciate you joining us.
Thank you, Manong. Thank you for the kind words. As Manong said, we met several years ago, and it's been a great partnership, if I can call it that. It's my role as an attorney. I've been practicing for almost 20 years now, and entirely commercial real estate, helping people buy, sell, develop, and then when necessary, sometimes it's unavoidable, fight about commercial real estate. But as Manong mentioned, my job as an attorney, I believe, is to help identify risk and then try to walk you through those risks, because sometimes there's opportunities in risk. You may be able to get a price reduction, but sometimes it's just the right time to say, hey, this is not going to be our deal. My job is not to kill a deal. My job is to make you aware of that and be a good advocate for your position. So thank you for the kind words, and I'm glad that this relationship is working out so well.
Perfect. Well, initially, when we were contemplating this presentation, we talked, real estate is residential or it's commercial. There's a lot of, asset classes within each. And what I found is once I started looking at the attendee list, a lot of you all are in real estate, whether it be professionally or as an investor, whether it's passive or active. And so I thought a better approach as it relates to title is to kind of put it together with the real estate life cycle. And so we may not focus on all four of these in equal time fashion, but acquisition, which speaks for itself, development, operations, and disposition. And we kind of broke it down in that respect. From the kind of get out, we'll probably spend, I would say, a good half of our time on the acquisition side. Interesting enough, acquisitions are of course happening all the time. A lot of opportunistic acquisitions are happening now with the macro climate of real estate. And what we're going to try to also do is kind of what floats to the top, as it would be, pearls. I was kind of joking with Brad. I had to put my doctor hat on a little, and especially with emergency medicine, some of the most common diagnoses we see are heart attacks. But in fact, and as serious as heart attacks are and how common it is, it's very easily missed. And so if anything can be crosswalk over to title, is there things that are catastrophic or, crucially important in a transaction but are easily missed? And so maybe those are some pearls that we'll be able to pick up from these parts of the life cycle, as it would be. But we'll just kind of jump in here. The first part of the life cycle, of course, acquisition. And Brad, I'll kind of turn it over to you. We kind of came up with these 5 main issues, and maybe some case scenarios as it relates to each one, so people have something to kind of anchor to. And I'll let you kind of take it from there.
Yeah, thanks. So, when we get started on this, one of the more important things that we do with a client is figure out what they want to do. What's their objective with the property? If they're buying a shopping center, I need to know what kind of tenants are going in there. If they're developing a shopping center, I'd like to know, what do they plan on building? Building a hotel, building an industrial park. So understanding what we need to be doing first. And then, because we need to make sure that your objective can be met. And so once we finish the contract, we put the contract into the title company, and the title company will provide the commitment for title insurance to us about a week to 2 weeks later. And we just really start digging in at that point. So a Texas title commitment, which we're in Texas and in Houston. And so, there's not, during acquisition, there's not really zoning in the city of Houston, but in the suburbs there are. So understanding what is going to be going into the property, or what the objectives are with respect to the property, becomes very important to us. Once the title commitment comes to us, we start looking through all of the documents, and you have 3 major sections of a title commitment. You have the Schedule A, B, and C. A really talks about the ownership, and then the property description. B talks about exceptions to title, and we can get into that. And C talks about issues that need to be resolved before closing. And so, one of the main things that I see happening, or sometimes I see happen, that becomes a real problem for us, is when we get the title commitment, we'll see that the person that my client has entered into the contract with is not the same person that actually owns the property. Obviously, that's a red flag. So I mean, we always look to make sure that the person that we're contracting with is actually the person that owns the property. And
So,
another big,
Brad, maybe interrupt you there. So, because you may need to elaborate on that, in that, the seller may not be the seller. Let's just kind of level set there, and give us maybe a scenario where that is the case, because it almost seems like inconceivable, like who is selling and why are they not the same person that's going to be at close?
and it can be a lot of different reasons, Manong. I mean, it might be that it's a flip situation where we're entering into a contract, and maybe unbeknownst to our client, the person that we entered into the contract with has the property itself under contract with someone else, with the true party owner, and what they're planning on doing is making money off of the deal in that way, which isn't necessarily a bad thing, but it's one of the things that we need to look into, right? We need to understand that situation. It could be that there's a gap in title, could be a probate issue, could be just like a gap in title, meaning that the deed that they thought had been recorded never got actually recorded. So what we end up doing is start digging into this and making sure, we just need to look, and we need to understand, why is this happening? Another thing, when we talk about the property, we need to make sure that the property that we are entering into the contract for is what's actually the legal description owned by the client. A lot of times you'll see, you get the survey around the same time, and you look at it and you say, wait, this doesn't match up. I'm buying 4 acres, and it shows here you only own 2 acres. So these just become issues that we have to look into and understand what is going on. there.
So so I think for the real estate professional, they probably understand that, but there's a lot of, I would say, passive investors that want to put quiet money away, buy a piece of land, maybe in the path of growth, and they may not have the same advisory, right? So they're seeing a piece of property, and so they're going to probably likely seek out legal help. But how do they get those ducks lined up on the front end? Like, what would you like them to, the questions, maybe say 3 or 4 that they're asking, whether it's paperwork or what have you, or documents or surveys, particularly as it relates to raw land. I think we talked about, like, if something is already existing, whether it's a shopping strip, or maybe a lot of those things have already been kind of fleshed out. But say a raw piece of land, not necessarily farmland, something that's commercial, how are they going to flesh that out?
Well, it really becomes, you've got to start reading the documents. You have to spend some time. I've been doing it for almost 20 years. And so, it's second nature to me. And I think, I'm going to end up just skipping a little bit, because it becomes second nature. If it's not second nature to you, then you really have to spend some time looking at that Schedule A, looking at the schedules, looking at the contract entity, and looking and seeing who actually owns that property and making sure it matches up. And if you don't understand something, or if something doesn't seem right, you need to talk with whoever your representative is. If you're represented by a real estate professional, you can talk with him or her. Mm-hmm. If they don't know, and they can't give legal advice, but it's not really legal advice for them. Just they can tell you, hey, I'll dig into it, or I'll look and I'll try to figure out what's going on. So if you don't feel comfortable with something, then you need to ask. You need to talk through it. The title company as well, you can work with them to say, like, hey, this isn't making sense to me. And if there is a discrepancy between the contract party and then the party that actually owns the property, there might be something in Schedule C, there might not be. Mm-hmm. So, that would be, but, just as important, I believe when I get the survey, we look and we want to make sure that the survey legal description matches the legal description of what we're supposed to be buying in the title commitment. And a lot of times there are discrepancies in those documents. And so, going through and making sure that what you are entering into, what the property that you think you're buying under the contract, is the same property that's being insured by the title company.
That's so, I mean, 2 big pearls, and while they're intuitive, they may not be as easy to tease out. Make sure the seller is the seller and know what you're buying. Let's just talk a little bit about kind of liens. There's a lot of type of liens. We talk about tax liens, mortgage liens, vendor liens, as it would be with the mechanics, as well as contractors. So is that a big problem, or is it become a big problem if you just don't know about it?
Yeah, I think so. The liens will be any type of encumbrance that is a competing claim or a interest in the property. It should be on Schedule C, and that will be mechanics and materialmen's liens. That might be a mortgage lien. There could be what's called an abstract of judgment. The abstract of judgment will show if the person you entered into the contract with has judgments against him, her, or their company, right? And so the ones and those are important to look at. And the title company, what you need to make sure of is that those get removed or released or paid off at closing. So in and of itself, it's not a huge problem, but it could become a problem. You just need to make sure that those get paid off. If they're not paid off, then you might have created an issue. So you need to make sure that those type of things are taken care of and paid off at closing. The things that are a little bit more rare, but can be disastrous. If you see something like a notice of lis pendens, which means that there's a pending lawsuit going on with the property, and that becomes, you really need to understand at that point. You really need to start digging in, and more than likely you have to engage an attorney at that point to start understanding what is going on. Why is there a lawsuit affecting this property?
Perfect. I know some of you all are asking questions. I'll get all of those addressed right at the end, so we have a solid Q&A section at the end. Sorry to have not mentioned that earlier. Let's talk about, well, you said that Houston, or I should say a lot of Texas municipalities are very loose as it relates to their zoning. But, one thing, of course, Chris and I developed largely in master plan communities, which oftentimes are small cities unto themselves. So let's just talk a little bit about zoning and maybe how that relates, and maybe some nuances and pearls that we can take away from that.
Yeah. So zoning is, in a lot of ways, it provides clarity to people who are trying to develop, and it's a box that needs to get checked. You look and you say, okay, I'm going to do an industrial building, and so you have to make sure that the zoning in that area will allow you to build it. So that's not as challenging, and where it becomes a little bit more nuanced is if you have an existing property that you're buying and the zoning doesn't actually allow for that. And then then it becomes much more nuanced, because then, you've heard that term grandfathered in, but it makes sense to really start digging in what that means, because it doesn't necessarily mean that you're forever okay when that happens. But the bigger issues when you're trying to develop something, especially when you're developing something like a retail center that's a part of a much bigger project or a master plan community, what you'll see like pad sites that are a part of a much bigger development. And there are a ton of restrictions that get placed upon the surrounding properties. You see, like big box retailers like Walmart will frequently do this. They don't want any competition around them. So they also don't want businesses that they think are unsavory or might hurt their business. HEB does that. So you really have to dig in and start understanding what those documents say with respect to, if you're developing in a master plan community. You have to understand what those instruments say, because it will very much dictate, if you can put a liquor store, if you can put a daycare, if you can put a pet boarding place, because obviously there's going to be noise associated with that. If you could put a restaurant that's going to emit smoke, these type of things, these are the type of things that you'll have to look through and make sure that we will read those and make sure that that's actually something that it goes back to what I said. What do you want to develop? And then we need to make sure you actually can develop it.
No, I think you bring up a very good point. We're building retail shopping centers that have that are multi-tenant retail. And if there is a restriction that prevents us from putting a specific type of food user or what have you, it really diminishes, and to a certain degree makes it even more difficult to lease up. And so while it may not necessarily impact the material value of that piece of land, it certainly will materially impact the vertical structure that we're trying to put up. So yeah. I think that's a very, and whether that's leasing versus zoning, or it kind of falls into that same thing, but I think you hit on a very important point, which is kind of read through the fine lines of usage or allowed usage.
Yeah, one of the more complicated issues, and I've seen it just very recently, in existing retail centers, very big retail centers, in a lot of ways, the title work is more simple in those, but to some extent, it might not be, because you might see, the title work where you've got to look into the documents to see what it says, but there could be provisions in there that say, if you do something that's wrong, then one of the tenants can terminate the lease, or they can pay reduced rent. If you tried to build in a site corridor, that you might end up creating an issue that you get yourself into a lawsuit. But I see they're called co-tenancy requirements, and they happen very frequently. And if A tenant leaves, then B tenant can leave, which would be a disaster. And if B tenant can, and if A and B then leave, then C tenant can pay half rent. And so you'll see these things happen where people come to me and say, hey, what's going on here? This provision, I wasn't aware of this. And so it really is the fine print that you got to dig into.
Yeah, just to kind of elaborate for you all, what Brad is really talking about is, let's say you have a power center that has 2 or 3 25,000 square foot users, whether it's a clothing outlet or a clothing type of store. And then they feel like because they're adjacent to another national tenant, there are synergies. And if one were to leave, they have the opportunity to leave themselves. Am I kind of throwing that out?
That's correct.
So there's this kind of, not necessarily co-branding, but there's synergies with certain stores being adjacent to each other. I think this is crucial as it relates to a lot of acquisitions, value add acquisitions in shopping strips that do have these junior anchors. And as you start to look at the leases, sometimes leases are signed not necessarily on the fly, but because of whether it be debt covenants or they're looking to exit, and they're not necessarily the long game. And now that may pose an opportunity for leases, but if you're paying a premium and a premium cap rate, it may not make a whole lot of sense per se.
Yeah, I think, Manon, one of my jobs, if not the most important one, once we understand if the client is buying a property and expecting a return on that property, one of my jobs is to make sure that that income stream is protected to the extent that we can. And anything that could materially interfere with that income stream would be something that the client needs to understand. And so, and it just becomes much more important. You brought up the issue with, in title, and it's not necessarily title, but you also have to dig into the leases because a lot of those provisions aren't put in the title commitment. They're in the leases themselves. And so really digging, I've had to do for clients, create a flow chart. If A, then B, if B, then C, and then provide like site corridors and restrictions, like one quadrant of the property can't be used for this, one property has to be used for that. And so it becomes very, very complicated. When you're dealing with the bigger type of properties, you'll see it more frequently. If you're buying a property that's a pad site or a property that's a shadow retail center off of a much bigger property, if you're doing what you're doing, which is developing in communities like you are, there are going to be heavy restrictions in that. We just have to dig in.
We're going to move on to, I think there's some fantastic pearls there for acquisition. It's always a frenzy for us on acquisition because there's just so many things happening in our due diligence periods. But I think every minute and every ounce of effort that's gone into those due diligence periods pay in spades. The development title issues, there's many, but we picked 2, particularly missing and unrecorded documents. So it's one thing to tease through the documents that already exist. It's another when they don't present themselves so easily. So maybe you can kind of elaborate on that.
Yeah. So the title insurance industry is not perfect. That is why you end up buying this insurance policy, because there are documents missed. I mean, I have 2 war stories that have impacted me in the past 18 months. I had one property that I bought that, there were several documents, a couple of easements, and then one other document that was like a cable document that didn't really impact it. But there were 2 instruments that were missed by the title company. And I use this title company all of the time, but they were simply missed. And so there were instruments that impacted the development of the property that were missed by the title company. And so if we had known that, it would have changed the acquisition strategy. So, there are are instances where the title companies are just going to miss documents. That is the reason why you have the title insurance. So although it's disruptive, you should be okay. And there's really not much that we can do for you, because all we do is we read the documents that are provided to us. Title gets open, we see the documents, we read them. If something was missed, I mean, that becomes a pretty slam dunk case for a title company claim. And so that is it's complicated, but it's more straightforward. What I've seen that become more problematic, I've seen a right of first refusal / option, first option to purchase a property, and it was not recorded. And so sometimes there are documents that people will come and say, hey, I'm going to exercise my option now. And say, whoa. No one put me on notice that there was an option or a right of first refusal. I've seen a right of first refusal. My client purchased a shopping center, and then 6 months after my client purchased the shopping center, a tenant came in and said, I don't understand how you bought the property. No one ever came to me and told me about this. And my client didn't read the lease. The lease is where the option or the first right of refusal was in, where it was established. And because my client did not read the lease, we had an issue. There was an issue there. So
I'm going to have to interrupt you there for
Yeah.
just 1 second. So just to kind of elaborate for folks, and this kind of ROFR clause as it would be, is that if there is some type of sale or exit or some type of hurdle that some asset goes through, one of the tenants has an opportunity to buy, whether it be at a fair market value or a preset value. I know Chris does our leases with you all, and we've joked that some people want ROFRs into their leases. Maybe that's just to step back and say, like, that's not best in practice to do in the first place. Like, I know that's not a title issue, but that seems like an aged old clause that I don't see that often. Or are people still writing those clauses?
Yeah, we get asked to do it quite frequently. You'll see it more in a smaller shopping center situation, or a smaller, like any type of, like, I had it arise in an industrial building. I have a client Manon, that is buying a bunch of Walgreens, right? And there's right of first refusals in every single one of those. And the best practice is, if you are going to grant one of those, would be to actually file it in the real property records, in my opinion, because you want the world to know what's going on. And a lot of people own real estate, and they'll start acquiring a lot of real estate, and they'll forget that they even entered into these agreements. And and so I believe best practice, if you're gonna do it, first of all, I don't think it's a great practice to do it, but sometimes that's what it takes to make a deal. And so if you're going to do it, if you put that document in a unrecorded agreement, then you're just asking for there to become an issue, in my opinion. So, I do think it's best practice to go, if you're going to do it, then, we have what you can do, like a memorandum, where you don't tell the world exactly what's going on, but you just give some highlights of saying, hey, party A has a first right of refusal on this property. And, if it puts the world on notice, if an outside party tries to buy it, they go, like, if I were representing you, Manong, and we open title and it says party A has the first right to buy this property. Well, we're not party A. So I dig in and I say, who is this party? Like, have you already gotten that waiver from them? Like, have you already made sure that we've gotten past that hurdle? So, it doesn't have to be an issue, but if it's not dealt with, then it becomes a very big issue. The one where it was an unrecorded first right of refusal, it was 3 years. It was 3 years and several $1 million. Yeah, and ultimately, the seller got involved, my client got involved. It was just messy. And another thing that I feel like my job is, you said I was pragmatic, and and we're not people that want to get our clients into lawsuits, and certainly not something that we want. And so if we can, I like to identify the problem first before, the litigation process is unwieldy, it's slow, and it's incredibly expensive. So if I can identify these issues for my clients before, then I feel like we've added a ton of value to them. And sometimes it's very opportunistic. If I can identify issues, then I'll work with my clients and say, and I think this is where me being an investor comes in. I'll say, look, this is a problem. This seller really stepped in it here. I think we're going to have to go, and you get a reduction in this purchase price, because this is going to be a mess to clean up. This is going to be an issue we have to deal with. So
I think you just hit the nail on the head. If you were to take some big pearls away from this, is that title issues, there are probably more title issues than there are not. But understanding or equating an economic value to each one of those, and the heightened awareness that's associated with that, right? I mean, because I think you even said it when we were initially talking about this, is that most title issues can be mitigated and worked through, but there's an economic value that's associated with it. And with the cost of capital these days, it's going to be very erosive time that's associated with trying to mitigate these title issues.
Yeah. One other thing, before, I know we're, I don't want to get us too far behind, but on the mechanics and material men's liens, that becomes if there's a lien, that becomes a Schedule C item when you're acquiring it. So they should be taken off. But during development, you'll start seeing, and I see it happen, and we're involved in a matter right now where my client paid a general contractor millions of dollars. And it turns out that general contractor was not paying his subs. And so we started getting a lot of mechanics and material liens filed against the property. And my client was just totally confused. Like, what is happening? Like, we paid this money, and this construction company was just a bad actor. He paid the construction company, the general contractor, and the general contractor wasn't paying his subs. So when you're seeing these issues show up, if your client's not paying, then they should expect that there's going to be liens. If they're not paying their subcontractors and their material men for the items that are being used to develop the property, they should expect that they're going to be a lien filed on it. But I'm in the middle of it right now, and it's really tragic because my client's having to pay twice. And what you really need to do is be proactive. Really be on top of this, really be looking at the progress of the construction, where there are issues where it's taken way too long, where, and I encourage my client, go out to the property, talk to the subs, see how things are going, because if a subcontractor is not getting paid, they're going to complain about it. But, you look back and there are a ton of red flags. And my client, there's trust, and there's also an imbalance of knowledge and experience. And so I think, being proactive, and it goes back to, if you don't understand what's going on, or if it's not feeling right, reaching out, and whether it's someone like me or somebody that you trust that's experienced, another construction guy or girl, like, talk with them, figure out what's going on, because once you start seeing liens filed, it becomes a scary thing, because you can lose possession of your property, or you just get into a lawsuit, and it just becomes really messy to fight the mechanic and material men's liens.
No, I think that you're absolutely right. That and so for you all, this is actually a relatively new term, because I always think of those that are working on our assets, and particularly it's just general contractor. But when we say mechanics and material men's, we're talking about all the subs. So whether it's concrete, plumbing, electricity, lighting, all the associated vendors that GC and sub is using. Of course, they're obligated to pay them, and if they don't, they can put a lien on your asset. But just as you said, and I see this every day with Chris, is that you just have to be out on the site. You can't hand the checks over to a GC and expect them to deliver an asset 12 months later. It just doesn't work like that.
Right. We'll move on to operations.
Absolutely. Operations, I think this is incredibly relevant because we see a lot of, acquisitions, but value add acquisitions in the commercial space, particularly in retail. Of course, it can be in multifamily as well. But as we talk about particularly retail and office, yeah, let's kind of jump into operations as it relates to title. We
Yeah,
highlight some of these things.
I think we talked about the lease agreement, filing options, and rights of first refusal on the real property records. And that becomes, I think there should be some hesitancy to do that at all. Sometimes if it's a 2-tenant property and one tenant is occupying 80%, if that tenant wants this, you may have to say, okay, it's something I need to do. Right. And so, but it goes back to, you might be on vacation, or you might be incapacitated for whatever reason, or you might just simply forget. A lot of people own dozens of different projects and just forget that 8 years ago that they granted rights to a tenant. And so I always think it gives you kind of a reminder, oh man, I forgot I did that. And then once the title gets open when you're trying to sell it, then you may have violated that option, but it's a hell of a lot better than forgetting about it completely, than selling the property to someone else. And so putting it in the real property records is a good idea. And it goes to lease decisions as well. When you go in, and whether you're developing the property or leasing up an existing property, you might find certain uses they might be willing to pay more. A vape shop or a tattoo shop is not considered the highest type of tenant, but they may be willing to pay more. They may be willing to pay a higher rate than someone else, but you got to make sure that you're allowed to do that. And restrictions can be reserved in the deed, in a prior deed. Restrictions can be reserved in in other instruments, that development instruments. And so really looking through and making sure that the decisions you're making on leases do not get you into an issue. And so you really have to, it goes back to really having an understanding of what the rights and rules of that property that you were going to be buying and now you did buy. So it'll impact what decisions you make and kind of impact and direct which way you're able to go in the lease up phase. Or if you have a vacancy and you lease it back up again, you need to know who you're leasing it to and whether or not you can actually lease it to that type of user.
I had a couple of questions, and maybe this may have been applicable more on the development side. But we use the term easement pretty loosely. But in development, there's a lot of different type of easements. Maybe can you elaborate a little on utility versus aerial easements? We now building in some dense city areas are now seeing aerial easements. Of course, we always are dealing with utility easements. Maybe you could tease those two apart. That's one. And then the scariest term of easements, the big B word, blanket easements. So maybe kind of talk a little bit about that, just to kind of round out the conversation as it relates to easements and pearls related to that.
Yeah, an easement is a right, another person's right in your property that isn't an ownership right, but it's a right to use. It's a right to use in some way, some portion of that property. And the aerial easement, it'll usually say you'll frequently see it in utility poles, but you're seeing it in a lot of different ways, especially in much more dense areas where the space is really important. But you can have site easements, in front of a beach. nobody or beautiful mountain view, you can say, hey, you can't build, like I have a site easement on this property. Like you can't build above that, or you're going to impact my easement. You have utility easements. You'll have roadway easements. You'll have drainage easements. And so what you want to do, you got a big one in Texas, is a pipeline easement. Pipeline easements can be incredibly disruptive to a property because sometimes a pipeline will be running right through the middle of a property. And I've seen clients that bought property and a pipeline easement will kind of just dissect the property into two pieces. And I had a client that had a bunch of 18-wheelers, and the pipeline easement itself said, you can't park an 18-wheeler on top of this. And if it's over, I don't remember how heavy it was, you can't even drive over it. And so it became very disruptive to my client. It was in the real property records. It was on the survey. So these are the type of things that, if you look at the survey, if you read the title, then you're able to ascertain what is going on there. The problem becomes when you have a blanket easement, that can be a blanket easement is just like it sounds. It goes on top of, it could go over top the entirety of the property and covers it like a blanket. And, it may or may not be a disruptive aspect to the development, but, typically that is not something that you want, and you'll see a lot of times, I mentioned pipeline easements, but in Texas, you'll also see oil and gas leases. And that's where it becomes more of a blanket, where it's like, hey, we have a right to use this property for oil and gas activities, right? And so that can be very disruptive. And so, or there are kind of buzzwords, and it might be a little too much for this topic, but there's nothing that will completely kill a deal if you understand what the deal is. You can always go and you can talk with the seller, and you can talk with the predecessors in title and see if you can get these things released. I've had luck in getting things released. I've had luck, but not exactly the way I hoped we would. Like we've had situations where there were easements and we tried to get them relocated, and it wasn't as good as we had hoped, but we got them relocated. It was costly. I've seen drainage easements. There was a drainage easement. It went like this, then went down, and it's like a bayou. Went through it, and we relocated it just to make it like that straight, so we could build on it. So, understanding the issue, you still might be able to fix it, but you first have to understand the issue, and you need to understand these issues like during the acquisition phase, if possible. So during the operations phase, you can fix it, right? The acquisition phase, if it's a problem, if you're buying a property for $1 million and it's going to cost you $100,000 to fix the issue, then during the acquisition phase, we'd say we need $100,000 off this property, or maybe even more, right? So at that point, your operations, like, what you're getting yourself into, and it becomes a cost of doing business on that piece of property.
Again, economic value of finding something.
Correct. And we talked about the mechanics of materialman's lane. I mean, if you're not paying stuff, then at some point you're playing with fire, and you're also really going to upset your lender, because your lenders start saying, if you have a loan, why aren't you paying? Why aren't you paying this? And you might get in default with your lender.
We've kind of highlighted most things on disposition, but the first one, you gave me some information as it relates to advisable to use the same title company. Maybe elaborate on that. That may not sit well with a lot of relationship issues, but as you said, not everything is as easily discoverable. So, what's the intention behind that? Best practices as it relates to title insurance claims, or in just title insurance in general?
Yeah, part of it is just the best practices. And, the title insurance industry is comprised of humans, and humans are fallible. And when you acquire a property from, let's say you acquire a property in 2010, once you bought that property, the prior lien should have been released. But a lot of times what you'll see happen is the prior title company will fail to have released it. And it's not a huge issue, but it's just a matter of preference. If you use the same title company, then a lot of those issues, like, wait, you're the ones who closed this property. It needs to be the same. If you use the same title company, then those liens, like, hey, you closed it, so you should have released that lien. And the other thing is like when I said, sometimes instruments are missed. And so if they missed them in the first time, if they try to bring it in the second one, it becomes a slam dunk title claim. Say, like, look, you missed this the first time and now you're trying to bring it up the second time. Like, you need to fix this. Like, in real time, you need to fix this. And so in my experience, it helps grease the wheels a little bit. Because it's the same people, or it's the same, underwriters and same title company that's working on it. And so a lot of these things that should have been caught the first time, if they weren't caught the first time and they show up on the second time, the issue feels to me like it gets resolved a little bit quicker.
Fantastic. Well, why don't we jump into some Q&A? We already do have one question here. The last slide has our contact information. And if you all have questions, definitely type them in and we'll try to address them. The first one's from Rob. Do land trusts play into this as well? I think this came into the when we were talking initially about an acquisition. If I'm not mistaken, as it related to liens and encumbrances. So maybe we can talk about land trusts.
I mean, like the reality is, when you're, and I saw it come through, and I think it was at the beginning. The reality is, when you open title, whether you're buying it individually or a company or a trust, the same things apply. You need to understand what the property, what you're buying, what restrictions there are, what impacts there are. So not exactly sure what he's asking, but yeah, when you're buying a property, the title issues are the title issues. You need to understand them.
For sure. Open for questions, folks. Maybe some just high yield pearls that you've seen over the last 6 or 12 months as it relates to the economic climate and what you see. I mean, what are your biggest transactions? We're doing a lot of land transactions. Are you seeing a lot of a value add in, say, office space or in the retail space or multifamily space, and things that may have come up in title?
Yeah, we've we're involved. I'm involved in trying to acquire an office building right now. So yeah, there are opportunities. When there's risk, there's an opportunity, and the risk needs to get baked in, right? And so you look at it. There's a lot of disruption in the apartments and office space right now, and so, and it's those challenges in that space are compounded by how expensive it is to borrow. And so you're seeing just a general, it's felt like it's been this way for the past 18 months. It's just a general uneasiness with, what the future is going to hold. I kept thinking, I felt like the last quarter of 2022, I felt like 2023 and 2024 was going to be disastrous. And, the business has been different. It's been slower. It's been more challenging. And there's been activity, but you don't see a ton of completion of deals. But it does feel like people are starting to come out. We've been very, very active in the development world. part of it is with you. The Malabar Hill guys, you guys have been very active, but we have several clients that are very active in the development space. That seems to be more active than almost any other space now, which is really surprising to me. But
Well,
yeah,
I tell people is that, timing means a lot. Whether it's luck or not, we have foresight. We know what the cost of capital is. So it's not a guessing game. We know it's high. So if something pencils out, then, we know exactly what we're kind of getting into, which is a little bit different than, say, 2 years ago, where interest rates were going up. We didn't know where they were going to land.
The beauty of the development too, I think you're right, Manong, is you guys build it, and if you can make money when you're having to borrow at 8%, and when it goes down and you're able to refinance it, you've baked in the high interest rate through the development, and then once it's stable, and by that point, I'm assuming and I expect interest rates should be down. It's going to be found money once you go through and refinance the property. So
my view is just, it's more macro than that. We believe in Houston. Houston continues to have consistent job growth. So I think that's probably where we see opportunity, where we're just basically capitalizing on residential growth behind that.
We've seen a lot of, we have quite a few people that are involved in industrial. Industrial has been the darling of real estate right now, in my opinion. I mean, it's been very expensive. Yeah, I think it's perceived as one of the safer assets. So we've been pretty active in that. Leasing has been very active. Apartment complexes, you're starting to see a lot of disruption in that space, and it's a lot of fights there, a lot of missed projections, and it's just that part is not gone as well.
For sure. Well, we'll kind of wind it up here. A good showing here of over 30 people. If you would like the PowerPoint presentation, just DM me. You can just do it right back to the invite itself on our CRM, and I'm happy to send it out. This recording will also go out. And just reach out. Questions. A big part of my role at Malabar Hill is educating what we do. Brad's job, I think, as he has demonstrated, is also to be just a really great advisor in just educating those that we work with and the network as it would be.
Yeah. Well, thank you, Manong. Thank you for this opportunity. Thank you for everyone that joined. And if there's anything I can do to help, just feel free to reach out.
Ciao. Everyone have a great night. Thank you.
Yeah. Bye-bye.